Hello, my name is Ben Rowe, and today's presentation will cover my marketing strategy for the upcoming CWF Live event, with additional information regarding the CAN-SPAM Act of 2003. In this presentation, I will give you a brief overview of the CAN-SPAM Act of 2003, criminal liability, spam and the First Amendment, the General Data Protection Regulation, or GDPR, and effective email marketing, and we'll wrap up with effective keys to success to have a successful marketing campaign. We'll start today's presentation with a brief overview of the CAN-SPAM Act of 2003. According to the Federal Trade Commission's website, the CAN-SPAM Act is, quote, a law that sets the rules for commercial email, establishes requirements for commercial messages, gives recipients the right to have you stop emailing them, and spells out tough penalties for violations, end quote. To apply these rules and protections, the law established 7 guidelines that companies and advertisers are expected to follow to stay in compliance. Those guidelines are as follows. The first is don't use false or misleading header information. This means the from, to, reply to, and routing information must accurately include the name and email addresses of the originating domain, while also identifying the person or businesses that initiated the message. The next guideline is don't use deceptive subject lines. Now, this guideline is self-explanatory. We just had to make sure that the subject line accurately reflects the content of our message. The next is identify the message as an ad. It's important that the recipient is aware the email is in fact an advertisement. The CAN-SPAM Act gives a lot of leeway and flexibility on how to accomplish this, but the message must clearly state that it's an advertisement. Next up is tell recipients where you're located. Very simply put, the physical address of the company must be disclosed to the recipient. Next we have tell recipients how to opt out of receiving future emails from you. To accomplish this, a simple link or reply email address can be provided to the recipient to allow them to opt out of future emails from the company. Next, we must honor the opt-out requests promptly. The sender of the email must respond to opt-out requests within 10 business days of receipt, and we cannot charge a fee to the customer for opting out. Additionally, once the customer has opted out, the sender cannot sell identifiable information about the customer at any time in the future. And finally, the company is required to monitor what others are doing on its behalf. Whether the email marketing is conducted directly by the company or contracted out, the company is ultimately responsible for the email marketing. Should the work be contracted out, however, both the company and contractor are responsible for any and all email advertisements. Since being signed into law in 2003, there have been multiple discussions regarding the legality of the CAN-SPAM Act and whether or not it conflicts with protections provided by the First Amendment. While there have been multiple legal challenges to state-level spam laws, there have yet to be any successful challenges to the CAN-SPAM Act. Now, some may argue that spam falls under the First Amendment, and while it does guarantee free speech, it does not allow that speech be forced on others. Furthermore, the CAN-SPAM Act does not explicitly ban any sort of speech. Rather, it requires specific information be included in the message to provide accountability to the content creator in the interest of protecting the recipient. Whenever discussing the topic of commercial speech in the First Amendment, a commonly asked question is whether commercial speech is protected differently by the First Amendment than individual speech. In 1980, the Supreme Court ruled that in some cases the First Amendment does in fact protect commercial speech, however, under a more stringent standard. Under the Central Hudson test, the only way for the government to censor commercial speech is under 3 circumstances. The first circumstance that must be met is the governmental interest in regulating speech is substantial. Secondly, the regulation directly advances the stated governmental interest. And finally, the regulation is not more extensive than necessary for the previously asserted governmental interest. If those three circumstances are not met, the First Amendment protects commercial speech. It is important to note that while there are some protections under the First Amendment, criminal liability does exist, and a company can be charged with a crime for the CAN-SPAM Act violations. In addition to criminal charges, companies and individuals could be charged up to $43,792 per violation. I would next like to discuss the GDPR, or the General Data Protection Regulation. The General Data Protection Regulation is the core of Europe's digital privacy legislation. It protects citizens of the EU and gives them more control over their personal data. Under the regulation, corporations and entities operating within the EU are responsible for ensuring that personal data is gathered legally, under strict conditions, and is protected from any misuse or exploitation. Failure to do so results in severe penalties. While your company is based in the United States, the GDPR applies to all companies operating within the European Union. While there are regulations in the United States and abroad that set guidelines for email marketing, it can still be a very effective tool. Sending advertisements that include links to your various social media accounts, previews of talent that will be in action at Winter Warfare 2, links to previous live events, and links to ticket purchases will maximize the use of any emails sent out to fans. This can be done effectively and legally, as long as guidelines set by the CAN-SPAM Act and GDPR are followed. As I close this presentation, there are 3 important points to remember as we move forward in this marketing campaign. First of all, we must be honest. We must remember to properly identify ourselves and the intent of advertisement emails that we send out to our fans. Secondly, we have to remember that privacy matters. With links being provided in our emails, as well as personal information, it's vital that we remain vigilant in the protection of personal data and any other relevant information pertaining to the recipients of our email advertisements. And lastly, we must remember the guidelines. As we prepare to launch this marketing campaign, we must remember to abide by all rules and regulations laid out by the CAN-SPAM Act and the GDPR. By ensuring all rules are followed, the likelihood of litigation, negative press, and/or negative impressions by current and future fans is greatly reduced. I look forward to working with you on this project, and I thank you for your attention.